I'm Ben Meiselas from the MeidasTouch Network. Judge Aileen Cannon, the federal judge in the Southern District of Florida, presiding over the document case involving Donald Trump as a criminal defendant, just made a surprising order. For now, she is keeping the May 20th, 2024 trial date involving Donald Trump as a criminal defendant. Many people expected that she was going to make an order to move that date, but she is keeping that trial date. So if all things remain in place, there will be a March 2024 trial where Donald Trump is a criminal defendant in connection with his attempt to overthrow the 2020 election. That's the case in Washington, D.C., before federal judge Tanya Chutkan. And then in May, you will have Donald Trump's willful retention of national defense information case before Judge Aileen Cannon. Now, my opinion is, and I will share the opinion in a little bit, is that this order is still a ruse. I believe that Judge Cannon is keeping the May 2024 date because she doesn't want the judge in Georgia in the RICO case, Judge McAfee, to set a trial date in May 2024 in connection with the Fulton County District Attorney's case. So that's why I believe Judge Cannon's preserving this date and will ultimately move the date to late 2024, probably 2025. But for now, that May 2024 trial date remains in place. Let's take a look at the court's order that was just issued. Here's the revised scheduling order of the new pretrial deadlines. And here, Judge Cannon states all previous remaining deadlines in the court's July 21, 2023 order are superseded except calendar call and trial. That's how we know that the May 20th, 2024 trial date is still in effect. Additional deadlines and hearings to be set and noticed as necessary. And so here we look at the new deadlines, the completion of security clearances and read-ins, now November 16, 2023. The special counsel's SEPA Section 4 motions have now been moved to December 4, 2023. Any defense motion related to ex parte nature of SEPA Section 4, December 4th, 2023. Defense response to special counsel's motion for disclosure of advice of counsel defense, December 29, 2023. Joint discovery status report, January 9th, 2024. Special counsel's Rule 16 expert disclosures, January 12, 2024. The defense motions to compel discovery, January 16, 2024. Defense challenge to Section 4 motions, January 23, 2024. Special counsel's response to defense motion to compel, February 2nd, 2024. Hearing on the Section 4 SEPA motions, February 15th to 16th, 2024. Pre-trial motions, February 22, 2024. Scheduling conference, March 1, 2024. And she says at the March 1, 2024 scheduling conference, she will then assess whether the May trial date will take place or not. And if you're having pre-trial motions are due February 22nd, 24, I still find it very hard to believe that she's going to keep this May trial. She's already delayed everything by 2 or 3 or 4 months in some cases on some of these other motions. So it seems that she's built in the delay to try to move this trial. But for now, she's keeping the trial date. Just take a look at some other portions of this motion, and then let me share to you, I think, what's really going on here and Judge Cannon's strategy behind it. So here you see it's an order granting in part defendant's motion to continue pretrial deadlines and denying without prejudice the motion to adjourn trial. Without prejudice meaning that could be brought again in a request for extension of the trial, and continuing that trial to a later date can still occur. And by the way, I think it's likely to occur. It says, this matter comes before the court upon defendant's motion for a revised pretrial and trial schedule. The court has reviewed the motions, the special counsel's response in opposition, the additional filing on the subject, including the various responses to the standard discovery order. and the classified supplements to these materials in full record. The court also held a hearing on this motion on November 1, 2023. So just think about that. The way the court, has continued all of these deadlines, on or around October 6th or October 9th, the court issued a paperless minute order staying and continuing all the deadlines to October 19th. October 19th, the court issued a paperless order holding a hearing on this on November 1st. So nothing happened between the 19th and the 1st. On the 1st, the court held a hearing, and then on November 10th, she issued the order. So it's been over 30 days since she initially started staying her own deadlines for her to even issue this order. And then she says, following review, it is ordered and adjudged as follows. Defendant's motion to continue pretrial deadlines are granted in part and for the reasons stated below. Defendant's motion to continue trial currently set for the 2-week period commencing May 20th, 2024 is denied without prejudice to be considered at a scheduling conference on March 1, 2024. Following the initial set of pretrial and SEPA steps in this proceeding as outlined below. So she's saying we're keeping that deadline, May 20th, 2024. We're keeping the trial date that is in place. But on this March 1st date, when everybody comes in, we will now hold a hearing, and then we will determine if the trial needs to be continued. But for now, we are keeping that May 20th, 2024 trial date. The court gives her own background on the case, where she doesn't mention that it took her about 3 months before she signed the SEPA protective order for no good reason. She doesn't mention in her background of the case how Donald Trump's lawyers and the lawyers for the co-defendants took exceedingly long time to submit their applications to receive the security clearances necessary to be the lawyers in this case. We don't see any of that here. And then the court then says, in the midst of all of the foregoing, the process of establishing an accredited facility in the northern division of this district remains in progress, slated to be completed in early 24. The investigation in this case commenced in February 2022, but no efforts were taken to initiate in earnest the establishment of such a facility until after this case was indicted, and adding additional logistical challenges. So just that gives you her perspective there, that she's blaming the government and special counsel Jack Smith for not building a sensitive compartmented information facility in the in her division of the Southern District of Florida, in the Fort Pierce division in the Southern District of Florida. What she should have done is said, hey, I don't have a SCIF here. I don't have a sensitive compartmented information facility where classified information needs to be reviewed. Rather than force the government to build one next to me, maybe I'll just say that we're going to hold this trial in Miami, which is closer to everybody anyway. Like, let's do the case where there is a SCIF. But so just so you see her logic here, basically blaming the government why there wasn't a SCIF that had to be built in Fort Pierce until recently. There's SCIFs in designated areas across the country. It's not like, hey, we know Judge Aileen Cannon's going to be assigned a case in the future, so let's build a SCIF next to Judge Aileen Cannon, who's never tried a SEPA case before. And then the court goes on to say, all of this leads to the instant motion. Defendants seek a revised schedule of pretrial deadlines in this case, citing various reasons. Delays and omissions in the productions of discovery from initial commitments by the special counsel, including materials related to the charged counts. Sizable increase in the quantity of unclassified and classified discovery from earlier estimates. Inability to access some of the classified discovery until October 17, 2023. Contested motions to compel discovery, so on and so forth. Defendants also request an adjournment of trial now. And you see how she's like making the arguments there for Trump. And as you go through this, the only real surprise here, in theory, is that she kept the trial date of May 20th, 2024. But when you know what her strategy is here, it doesn't really, it makes a lot more sense. She's going to keep that trial date. She doesn't want there to be another trial in that May, June, July period. And by preserving that trial date that she's probably going to move anyway, what Judge Cannon's going to be doing is watching now. Is there going to be any delay in the March 2024 trial date with all of the appeals that Donald Trump is seeking in Washington, D.C.? So what Judge Cannon's doing is waiting to see if anything happens there. And if something happens in D.C., then you would think she would say, well, aha, then my trial goes first. No, then Judge Cannon's going to move it. Judge Cannon, I think, is going to move the date regardless. She's just preserving and protecting those months to make sure that there can be no other trials against Donald Trump in that period of time, a la the Fulton County District Attorney case, which would go right in that time frame if Judge Cannon right now made the call to move that trial. So that's where we're at right now. And if you look at it, March 20th, we have March 4th, 2024, Washington, D.C. case. You've got the Manhattan District Attorney later in March as well. You've got the Judge Aileen Cannon case, May 2024. There's no set schedule for the Georgia RICO case. We also got another civil case, January 2024, in the E. Jean Carroll defamation case against Donald Trump. So that's your lineup right there, folks. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe on our way to 2 million subscribers thanks to your support. Thank you for watching, and check us out at patreon.com/MeidasTouch.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.